So we'll go ahead and get started then.
Thank you.
All right, we're going to handle both cases at the same time. The first one is BRYAN Santos versus State, which is 18-1318, and Felix Castro, which is 19-385 versus State of Florida. Motions to determine whether sanctions should be imposed. And we will start with the older case, which is the BRYAN Santos case. And just kind of historically going through that, do you know when the record on appeal is supposed to be filed with our court?
I do, sir. The record on appeal is supposed to be filed in a timely fashion. I know that once the notice of appeal, that's the first step. And then once the notice of appeal is filed, generally what the court will do is provide a date by which the record is supposed to be prepared and submitted.
Do you know what the timing is for when the initial brief is due?
Yes, sir. I know that the timing for the initial brief obviously is set by the court schedule. I do both federal and state practice, but generally the initial brief, understanding is that it's going to be 30 days of when the initial brief is due.
30 days from when?
30 days from when the record has been submitted and everything is prepared.
Okay. Do you know what the 70-day rule has to do with anything in terms of filing a brief? Would you mind sliding over just a little closer to the microphone? Thank you. Okay. In the Santos case, this court issued an order June 13, 2018, because as of that time, and you were counsel of record in that case.
Yes, sir. That's correct.
As of that time, no record on appeal had been filed, and we ordered you to show cause why the case should not be dismissed because no record on appeal had been filed. Ultimately, you filed a record on appeal.
Yes, sir.
You filed in the Santos case an emergency motion to supplement the record on appeal, correct?
That is correct, sir.
And we granted your emergency motion. The next thing we got was notification from the court reporter that no arrangements had been made to pay for the transcripts that were the subject matter of the emergency motion, correct?
That is correct, sir.
Okay. And as counsel of record, if payment was to be forthcoming, it would have come from you or your clients through you?
That is correct, sir.
Okay. And no payments were ever made for that transcript, correct?
That is what I subsequently discovered, sir. That's correct.
We issued another order to show cause why the appeal should not proceed because there was no supplemental record. Did you file a response to that?
I don't believe there was a response that was filed, sir.
Okay. Then come December 26, after you'd had several extensions of time, we filed an order to show cause why the case should not be dismissed for failure to file your initial brief, correct?
That is correct, sir.
Okay. And what response did you file to that?
My understanding is that there was a response that was filed simply stating that, and I don't remember the exact verbiage here, sir, but to be honest with you, something to the effect of that we've been having difficulty with the family members in terms of obtaining the payment for that, if my memory serves me correctly.
You were then allowed to file the brief, correct?
Yes, sir.
And in that brief, you included a statement of facts.
Yes, sir.
within the brief, did you cite to the record on appeal or a transcript by page number in that brief?
For that particular one, no, sir.
Do you understand what the rules require in terms of citations to the record?
Yes, sir.
Do you know what number that rule is and what it requires?
Off the top of my head, sir, I do not know what the rule number is, but I do know that the rule, and would be the case for all briefs, is that when filing a brief, as in doing a motion or anything else, a party should, when making an assertion concerning a fact, cite to the particular page in the record.
Okay. And that's mandatory under our rules, isn't it?
It is, sir.
And you did not follow that rule, did you?
I did not, sir.
Then we issued our June 28th, 2019 order to show cause, in which we noted that after receiving 3 agreed-upon extensions of time, your argument in this case was 124 words, and basically relied upon the fact that, in your words, counsel had done a bare bones or a tennis kind of motion for a downward departure, correct?
Yes, sir.
Did you in any way in your brief try to explain why an or a tennis motion would have been less likely to be successful than a written motion?
No, sir.
Is there any requirement that it be a written motion?
There is not, sir.
What was there in your brief that you contend was not frivolous? In other words, what meritorious points did you actually argue?
If you give me one moment. The argument in this case obviously was a long shot. It's not the strongest or most effective one. My understanding, though, of what a frivolous argument would be one where you know full well the facts are not as you assert, or that there's simply no basis whatsoever for a court to agree. So, admittedly, in this instance, it's not the strongest argument. It's likely, obviously, to be denied. However, understanding the definition of what one would consider to be frivolous, I don't believe that it meets that definition. But admittedly, yes, sir. The record to support it was quite thin, and obviously the brief itself could have been much, much better written, and presented. Absolutely.
You did not make any real effort to show that his plea was involuntary, other than you claim that his counsel should have done a better job with trying to get a downward departure.
Yes, sir.
By the way, in the Santos case, with our order that brings you here today, we required you to respond within 5 days to acknowledge that you had received the order.
Yes, sir.
Were you aware that you did not comply with that 5-day time period, but that our clerk had to call your office to tell you to file it?
That I was not aware of, sir.
Do you know what date you did file your compliance? I'm sorry, your acknowledgement?
My understanding, sir, is that it was filed actually on that 5th day. That was my understanding. But
Our order was issued July 22. Your acknowledgement was filed July 30. That's not 5 days.
Absolutely, that's correct, sir. That I was not aware of, so unfortunately.
Why were you not aware? Weren't you the one that was going to prepare the document for filing?
No, sir. I was not.
Who was?
In the response that I put together for the court for both initial show cause orders, I tried to explain, and let me just say clear from the outset. I mean, answering your question, I'm going to tell you who's responsible, but in no way am I saying that responsibility should be shifted from me. Bottom line, at the end of the day, regardless of whether you have staff or not, the one thing that I was told, especially during my time in the Army, is that ultimately you're responsible. The work arrangement that I have is that I'm an independent contractor who provides a portion of his fees, and then staff provided to you. Any and all tasks for filing and things of that nature are submitted to the staff, and they have to submit those. The order was prepared, and then it has to be filed electronically. Obviously, given the importance of what happened here, I made the staff aware that it had to be filed within that 5-day time period. So I was not the individual who had to prepare it, had to file it.
Okay,
But ultimately, it's
the order
still-
to show cause directed you to file it, correct?
Correct. So it's still my responsibility. Yes,
And I'm
sir.
looking at your acknowledgement here, and it's got S, then your name typed. Did you actually approve this pleading to be filed, the acknowledgement? Or did somebody just in your office do that and type your name in?
That's an electronic signature, so
I'm asking, did you actually look at the document and approve it, even if you didn't type your name in there? Did you look at that document and approve it for filing?
yes, sir.
Okay, so then, if you had looked at the order and looked at that, then you would have known you had missed your time. You're required to file it within 5 days.
Yes, sir.
July 22 was the date of the order. Your certificate is July 30. It's not 5 days. You had the order, you filed that, you should have known it was not timely, correct?
Incorrect, sir. And only in this instance, sir, documents can be prepared ahead of time and then submitted and then filed late. So again, with all due respect to you, sir, that is incorrect to say that I looked at it, saw that the date was late. I was fully aware of the 5-day timeline. So I'm just saying that that's incorrect. There's an assumption there that's being made, which is that I looked at it, saw that it had gone past that date and time, which is not true. These documents have templates which automatically will put the date in. It updates it through macros, so it can be prepared beforehand.
So the document can be changed after you've signed it?
Yes, sir. Yes, sir. The document has macros in which the date will reflect the
Do you
date.
understand that when a document is signed, you shouldn't be leaving blanks?
Yes, sir. Yes, sir. Ultimately, it's my responsibility, though. Yes, sir.
Let's talk about the Castro case.
Yes, sir.
And again, we issued an order to show cause, same thing, same date, July 22, same date for the response, July 30th. Same explanation from you?
Yes, sir.
All right, and in that case, the first order to show cause was issued April 3, 2019, for you to show cause within 10 days. Why the case should not be dismissed, once again, because there was no record on appeal filed, correct?
That's correct, sir.
And following that April 3 order to show cause, you did not respond to that as of April 17th. In other words, within the 10 days, you didn't even respond to the rule to show cause, the order to show cause, correct?
That is correct, sir.
So on April 17th, we issued an order dismissing it after having given you an opportunity to show cause why no record had been filed. Still no record was filed by April 17th. The appeal was dismissed because of that, correct?
That is correct, sir.
Then on April 17th, after the case was dismissed, you then filed a response to the order to show cause and said because of an oversight, you hadn't responded to the order, and you hadn't, I'm sorry, it doesn't say that. You hadn't, due to an oversight, you hadn't filed a record on appeal.
Yes, sir.
Do you explain why you didn't respond to the order to show cause in your response? I'm not exactly seeing that.
No, sir, there is no explanation there.
You filed a motion to reinstate the appeal. That was your first motion to reinstate the appeal in this case. We granted it, correct?
Yes, sir.
May 29, 2019, there's another order to show cause why this appeal should not be dismissed for failure to file an initial brief in the case, correct?
Yes, sir.
And throughout this Castro case, you were counsel of record for the appellant, correct?
That is correct, sir.
So May 29, you had 10 days within which to file a response to that order to show cause. And you did not do that, did you?
No, sir.
So on June 11, 2019, in this case, we issued another order because you didn't file a brief and didn't respond to the order to show cause. We dismissed the case a second time, correct?
Yes, sir.
That order was dated June 11. 6 days later, on June 17th, you filed a second motion to reinstate the appeal, correct?
Yes, sir.
And this time you said there was a failure to properly calendar the due date for the brief, correct?
That is correct, sir.
In that response, do you in any way explain why you didn't respond to the order to show cause?
No, sir.
And the brief was, the appeal was reinstated, correct?
Yes, sir, it was.
And it's still pending? That appeal is still pending, or has it resolved by now?
No, sir. Mr. Castro's briefs have been submitted.
Okay, so it's still in the briefing stage? Are all the briefs filed by now?
Yes, sir.
Okay.
May I just ask a question?
Yes, sir.
When you get, in this case, you got 2 orders to show cause, both of which were disregarded. What do you actually do? When you got that order to show cause, what is it that you do with that? I'm trying to understand the thought process here and figure out whether this is some sort of problem in your office or a problem in your thinking about what your obligation is to the court.
I take seriously obligations to the court, and the reason being is because that reflects upon, ultimately, me, but more importantly, harms the client. In no way would there ever be knowledge of something and then simply disregarding things. It's just simply bad practice in every way. What I am struggling with here is trying to explain a period, and I'll just be very frank, where there were things that I was relying upon individuals to do that were not done. Bottom line, ultimately though, that's still my responsibility. The string of questions, and obviously my response is yes, yes, no, no. The reason I'm answering this way is because I don't want to offer excuses. Ultimately, it's my responsibility. It's my responsibility to monitor emails. It's my responsibility to keep track of the docket. Those are things that I should do. Once these issues came to a head, as they did with these 2 particular cases, made certain now that those issues will no longer happen in terms of getting new personnel and making sure that I no longer rely upon individuals, because these things are incredibly serious. At some point, painfully here, I've learned that there are simply some things that I cannot delegate. If I can offer just an example, at the very same time that these issues were taking place with these briefs, I was handling a state case for trial up in the Pensacola area and had another federal case. Requested that a notice of conflict be filed and notification be made to the federal magistrate, given that I had been ordered to go to trial on that date. I then received a telephone call from the magistrate clerk that nothing had been filed at all, and that I had, within 12 hours, to make my way to the magistrate court's courtroom the next day or face consequences. So this, unfortunately, was not an isolated incident. As I stated and tried to put briefly in my response to the order to show cause, these issues were not matters of me intending to disregard the court's orders, not pay attention or gain some tactical advantage, obstruct justice, or do anything like that in any way, shape, form, or fashion. So, Your Honor, problems in the office. However, again, ultimately, problems in the office are ultimately my responsibility. They're my responsibility to fix.
One thing, in the orders to show cause that we sent out in both Santos and Castro, we advised you to be prepared to discuss several other cases.
Yes, sir.
Because it came to our attention that these were not isolated incidences just with our court. We don't know about any other courts. We know about our court. And now you say you've had difficulties in other places.
That is correct.
But again, these are orders to show cause directed to you why your case shouldn't be dismissed, why your client's case shouldn't be dismissed. This is not, and I'm kind of following up on Judge Orfinger's here, this is not, you need to give better answers to interrogatories 10 days from now. These are the kind of orders that would get, I would hope, every attorney, any attorney who ever got such an order like this, God forbid you get one.
Yes, sir.
You would think that would really have your attention. And in these cases alone, those two cases alone, there were times when you didn't even respond to the order, and when you finally responded, you didn't explain why you ignored the order in the first place. So it's, I understand what you're saying ultimately, but this is not some kind of hypothetically the buck stops here. These orders are telling you to do things, and you weren't doing them, and we just kind of keep going along. We've got the, and I'll maybe move through some of these a little bit quicker, but in the Anglero case, 18-1289, there were 2 orders to show cause issued in that case because the initial brief had not been timely filed. Is that correct?
That is correct, sir.
And you're counsel of record the whole time in that case?
That is correct. No one else, sir.
And after the initial brief was filed 225 days after it was originally due, and it contained 4 pages of argument. Does that sound about right to you?
That is correct, sir. If I might, Your Honor, though, with regard to Mr. Anglero, I do believe that in that particular case there was an issue, again, with regard to getting the record. And I believe that's the case for, if not all, but for a majority of those cases. For example, there is a case, one moment, please. If I might refer to my notes just 1 second, sir. There's something I wanted to bring to the court's attention on this issue. 1 second. Yes, sir. In the case Jeffrey Davis, this is a case before the court now. There was an order to show cause that was issued just this past week, asking why the above style appeal should not be dismissed for failure to file the record on appeal in the case. I had my now current paralegal check and then contact the court and come to find out the record actually had been the record had been filed. And so that order was withdrawn.
Okay, good.
So this is what I was making reference to with regard to, in my response to the court's orders to show cause, about how now that there is a different individual in place who understands that emails should not be deleted, orders should not just be disregarded, things of that nature.
You have them bring the order to your attention and put it on your desk, print it out, tell you, what do you do?
That was always the response. What I've always told staff and what's being done now is if I ever get a call from a judge, I don't care if I'm on the phone with my mother, interrupt me. I need to take that call. If there's something that comes in that says show cause, that is not to be forwarded, that is to be printed out, brought to me, and for me to be interrupted so we can handle this.
If your office has a procedure for how to deal with orders to show cause, that should tell you maybe you're doing something wrong. If you get enough of those that you have to set forth a procedure.
I understand what you're saying, sir. That's not the case. That's not the reason. That is not the reason. That is not the reason in any way, shape, form, or fashion. The reason that I said what I said and what I talked about is that there are certain things that if they happen, the attorney needs to be alerted immediately.
Well, let's
So
talk about that, because again, in the Anglero case, 18-1289, we issued our order to show cause November 14, 2018, because you had sought leave for a supplemental record. Sounds a little familiar to the Santos case. One was not prepared. We gave you 10 days to show cause. You didn't show cause. You didn't respond. November 27, 2018, the court order says that no response was received to our November 14th order. Again, that sounds very familiar to some of the others. It's not a unique issue. You've got December 26, 2018 in Anglero, order to show cause, why the case shouldn't be dismissed within 10 days because no initial brief has been filed. Then the February 7, 2019 order to show cause, why the initial brief hasn't been filed.
I'll just ask this. When you get an email from the court, we serve everything electronically.
Yes, sir.
Typically, in most law offices, as I understand it, the lawyers designate an email address, which is usually their own email address, and usually a secondary email address, which is an assistant or a general box.
Yes, sir.
Aren't these orders coming right to your box, your email box?
They are, sir.
So this isn't a situation where you're not seeing the order, or at least you're not given the opportunity to see the order. It's coming right to your inbox. So my question to you is, what do you do when you get that order to show cause? I mean, in my years of practice in law, I never got an order to show cause from a court because I tried to actually follow the rules. I'm not saying that I complied 100%, but I actually followed the rules. So what do you do when this comes to your inbox, and presumably to your paralegal as well, or some other inbox? I mean, you're getting that. What are you doing with it?
When I get it, what I need to do immediately, first and foremost, is check and see if what's in that order to show cause is in fact correct. That's number one. Number two, immediately gather all the information necessary to respond to it, and then take whatever action is in there. So for
Obviously, that didn't happen in these cases.
That is correct.
What was the process that was in place? I mean, were you ignoring it? Were you just delegating this to a paralegal to say, handle it? I mean, what was going on?
I was not ignoring it. There was never a time when an order to show cause would come in and I would ignore it because I'm obviously aware of the consequences of what would happen. For some of these, for example, I think some of the details might be important. For example, with regard to the Anglero case, there was an issue. The reason I believe that the initial order to show cause came in for Mr. Anglero's case was because the record had not been submitted. Apparently, the accounting section in the office had not sent over the monies necessary in order for the court reporter to prepare it. And so, therefore, in that instance, when I found out about that, that was the first thing is, if this is in fact the case that the record hasn't been done, can we please make the payment? There was a third party in this particular instance that was responsible for paying. And I immediately tried to make sure that that money was paid, and therefore so that the record could be taken care of. Just again, as this, I referred here in this particular incident, which happened last week, literally the minute I now make sure that I am in fact the person checking my emails. I'm going to be very frank and honest with you, sir. It was not always the case, given the volume, that I would check the emails. My paralegal has access to the email and others. And there would be times either when I was in trial or doing various things where I cannot sit here before you and say that each and every email that comes in, I check. I do now. It's simply not something that you can afford to do. I also have specifically designated that for any emails that come, that they be tagged automatically as high alert and also sent to another email address as well. That is why in this particular instance, when this one came out, a show cause order, I immediately saw it and addressed it and resolved the issue. That is a practice that I should have employed beforehand, and I did not.
Okay. Let's talk about the Hayward case.
Yes, sir.
You were counsel of record throughout that, correct?
That is correct.
All right, and that's Caleb Hayward, 18-2082, July 24, 2018. We issued a rule to show cause why the appeal should not be dismissed for failure to file a record on appeal. November 27, another order to show cause why the appeal should not be dismissed for failure to file the initial brief. And all these orders were directed to you, and they went to you whether you read them or not. Is that
Yes, sir.
correct?
That is correct, sir.
David Davis versus State, 15-0302. You were counsel of record throughout on that case.
That's correct, sir.
Our order dated April 13, 2015, rule to show cause why the appeal should not be dismissed for failure to file an initial brief in the case.
Sure.
What do you do to make sure that an initial brief gets filed in your appeals?
What I do now is I no longer delegate filing. The brief is prepared. The brief now needs to be filed and will be filed by me. That was not the practice in the past, but that is what needs to be done now. Filing, proofing.
In the
and all-
Davis case, when you did finally file the initial brief, the state moved to strike it because you had not cited to the record, correct?
Yes, sir.
And on December 16th, we granted that motion to strike and ordered you to file a proper brief. And again, the flaw at that point was you were told on December 15th, we're not going to take your brief if you don't follow the rules and cite to the record on appeal, correct?
That is correct, sir.
And yet in Santos, you don't cite to the record on appeal, correct?
Yes, sir.
James C. Smith.
Yes, sir.
In that case, and you were counsel of record at the start of that case, correct? When the notice of appeal was filed?
That's correct, sir.
Somebody else came in after you.
Sir, if I could, because I think this one's particularly important. James C. Smith was sentenced. I represented him for his trial and his sentencing. At the sentencing hearing, the trial court was notified that he was indigent, and so therefore that I would be filing the notice of appeal and then preparing the subsequent paperwork for him to be represented by the Office of the Public Defender.
But the subsequent counsel advised this court that you had not notified your client that you were withdrawing.
That's incorrect. That is absolutely incorrect, sir.
Okay. His statement was factually incorrect.
Both the statement is incorrect and that alleged fact is incorrect. If anyone states that Mr. Smith was not told, James C. Smith was not told, that I would be withdrawing from the case, that is incorrect, 100%.
And in that case, in addition to filing the notice of appeal, you had agreed to do the designations to the court reporter and directions to the clerk,
Yes, sir.
and you did not do that initially.
No, sir.
That's correct?
That is correct.
Next, we have the Alberto Serrano case. Were you counsel of record there?
I was for trial and sentencing, yes, sir.
I'm sorry?
I was, sir, for both the trial and the sentencing.
All right, and in that case, our order April 12, 2019, rule to show cause directed to you why the appeal should not be dismissed for failure to pay the filing fee, correct?
Yes, sir.
April 26, 2019, we again issued an order to show cause, and again, you were counsel, pointing out that you had neither filed a affidavit of insolvency or an order declaring your client insolvent or the $300 fee, correct?
That is correct, sir.
And we dismissed the appeal.
Yes, sir.
Has the case remained dismissed, or has it been revived, or do you know?
The last I checked, sir, is that the case remained dismissed. If I could, though, some information on the record with regard to that. Mr.
Certainly.
Serrano, in my last conversation with him, directed that I speak with a
Can you
family.
speak up a little bit, please?
Mr. Serrano directed that I speak with a family member, in fact, his brother, concerning what he intended to do as far as financing the appeal. At that point, the family then informed me that they did not, they were going to seek other counsel, given the fact that I represented him unsuccessfully at trial. And the last communication that I had was that the family was not going to ask me to do anything further with regard to the appeal. But there's obviously, but no.
Did you tell us you were not going to pursue the appeal, or did you just ignore our orders?
Sir, that was not the appropriate way to handle that. That is correct. Their motion should have been filed to withdraw in that case and to ask for counsel to be appointed.
All right, next we'll talk about the Jason Elaine Bacchus case, 19-0103. You were counsel of record in that case?
Yes, sir.
Or maybe still, I'm not sure what the status is. The notice of appeal, in essence, was kicked back to you for formatting, shall we say. It did not reflect that a copy had gone to the Attorney General's office. You were ordered to correct those defects. And also, there was a question of whether the notice of appeal was timely filed. Is that correct?
That's correct, sir.
So that's our January 11, 2019 order. January 25, 2019, we issued another order in which we say the appellant failed to respond to this court's January 11, 2019 order to show cause. That's correct, isn't it?
That is correct, sir.
And by appellant, we're talking about James W. Smith, III, U, correct?
Yes, sir.
And because of your failure to prosecute the appeal, that case was dismissed, correct?
That is correct.
Then you filed a motion to reinstate the appeal, correct?
Yes, sir.
Our order dismissing it was January 25th. Your motion to reinstate was received February 18th. So a couple of weeks later?
Yes,
More
sir.
than a couple of weeks later?
Yes, sir.
Do you explain in your motion to reinstate the appeal why you failed to respond to our earlier order?
I do not. However, I can inform the court of something that I think is important and relevant with regard to this. Mr. Bacchus is currently my client again on another alleged violation of probation. Mr. Bacchus, frankly, back and forth concerning what he wanted to do. The initial issue with the notice of appeal was getting the actual fee from him. So, no, there was no explanation with regard to that, but I can tell you that ultimately Mr. Bacchus's decision is that he did not want to appeal after I explained to him that the theory that he was choosing to advance, frankly, was going to have no merit. And the reason I just want to make sure that that's clear and important is I want to put at least that information on the record that there was some discussion. I don't want in any way for this record to be left with the impression that there's no contact or discussion with Mr. Bacchus on these issues.
Ultimately, at February 19th of 2019, we determined that the notice of appeal had been untimely filed, correct?
That is correct.
So regardless of your conversations, once the notice of appeal was not filed within 30 days from the date of the order or judgment, it didn't matter what your discussions were after that, did it?
Right, but the discussions I'm talking about, sir, were not discussions afterwards. Those were beforehand.
Does that case remain dismissed?
Yes, sir.
And that was dismissed without prejudice for Mr. Bacchus to file a petition for belated appeal if he can do so, or should?
Yes, sir.
And again, you were counsel of record, you got the orders to show cause, and if no response was filed, that's on you, correct?
That is correct, sir.
All right. We issued a show cause order in that case, and that's 17-3650, to file a proper amended petition with the proper oath. That was not done timely, so we had to issue another order, December 14, 2017, asking why it should not be dismissed for failure to file the petition. And by the way, why didn't you respond to our earlier order, correct?
Yes, sir.
And that's, again, if you got the orders, and if there was an obligation to respond, that's on you, correct?
Yes, it is, sir.
And you ultimately filed an amended petition for belated appeal, correct?
Yes, sir.
That was done January 9th. Our order to show cause was dated December 14th, and the earlier one was in November. And you finally filed it in January?
Yes, sir.
And on that particular case, your initial brief was filed 103 days after it was originally due. You cite two cases, and the meat of the brief is approximately 1.5 pages in terms of argument, correct?
Is this Mr. Hayward, sir?
No, this is James.
I'm sorry, sir. Okay.
You
Keith
cited,
James.
in that case, you cited two cases, Ball versus State, Pagan versus State. And in terms of your argument, it's contained on 2 pages. And on the second page is also contained your conclusion on a certificate of service. So I would say, giving you the benefit of the doubt, your argument's 1.5 pages long,
Yes, sir.
yet filed 103 days after it was due.
Yes, sir.
These are cases where you're privately retained, is that correct?
That is correct, sir.
These are not, you're not court-appointed, you're not taking these on intentionally pro bono, whether you ever get paid or not. These are not pro bono cases through legal aid or any kind of a court appointment, correct?
That is correct, sir. I would point out what you referred to, though, about the compensation. And again, I just want to be very clear about that. They were effectively, for the most part, pro bono. Yes, sir.
Whether you get paid or not, does that have anything to do with responding to our orders?
Of course not.
All right, Webster versus State.
Yes, sir.
Case 17-3945. Again, the appeal was commenced without either payment or an affidavit of insolvency. Is that correct?
That's correct, sir.
We issued that order December 14, 2017. Why shouldn't it be dismissed for failure to pay or failure to have an order declaring appellant insolvent? January 10, 2018. Our order is appellant, meaning you, of course, shall within 10 days show cause why the appeal should not be dismissed for failure to comply with this court's December 14th order regarding the filing fees. So there was apparently no response in almost a month to the December 14th order, correct?
Yes, sir.
And again, that's an order you would have received, and if it wasn't filed, that's on you, correct?
That is correct, sir.
On January 26th, 2018, in that same case, we dismissed the case because still no filing fee had been paid and no order of insolvency, correct?
That's correct, sir.
And more than a month after the case was dismissed, you filed a motion to withdraw from representation as counsel of record in that case, correct?
That's correct, sir.
That motion was filed March 9, 2018, following dismissal on January 26, 2018. And in that motion to withdraw in paragraph 1, among other things, you say the appellant is indigent and cannot afford the services of the undersigned, correct?
That's correct, sir.
If the appellant was indigent, why didn't you assist in obtaining, as this court ordered, either pay the fee or get an order declaring him indigent as you say he was?
Because he was not beforehand, sir. Beforehand, he was not. That's why I didn't do it. Beforehand, his father was providing the financing for the notice of appeal. Thus, if I had filed a notice with this court stating that he was indigent when he was not, I would have been stating something that was incorrect. The difficulty with this case here, and sir, and I think this is why it's important to put the details out, and I'm glad that you asked me that question. The reason I didn't do so, again, to emphasize, is because that was not, in fact, the case. Mr. Webster's father financed the initial hiring of us for his sentencing and for his appeal. In this particular case, and I can tell you, and this is an unfortunate thing that happens, family members make commitments in order to pay and to take care of certain things. And then unfortunately, those commitments end up not being met. What I think is incredibly important is I don't want it to appear from this questioning and the responses that this case was dropped when that was not in fact the case. I, in particular in this case and others, but specifically with Mr. Webster, repeatedly, weekly, reached out to his father to let him know that there were timelines and things that needed to be done, and on more than one occasion was either stood up or his father missed me and failed to come by. We also sent correspondence numerous times to Mr. Webster and set up opportunities to talk with him to explain to him, your family's hired us, they've stopped paying. If they're not going to pay, then we can move to have you declared indigent. Our mail was returned, and on at least 2 occasions, Mr. Webster declined to talk to us.
You're saying, though, that his father gave you the money to commence the appeal so that he was not indigent at the outset?
What I'm saying is that the father hired us.
I'm asking you very specifically. I thought you said that his father gave you the money to start the appeal. Is that correct or not?
No, sir. Let me,
So
what I said was,
you were never given any money to start the appeal.
no, sir. We were hired to represent Mr. Webster for his sentencing and any subsequent appeal. We were also very, very clear when we told Mr. Webster's family that hiring a lawyer involves fees and cost. And some of those costs will include getting a transcript and any filing fees. So, with regard to the transcript and the filing fee, and I think I see the import of your question, no, we did not have the money available at the time to be able to pay the filing fee.
You had money to pay your fee?
Sir, the amount of money that was subsequently paid in that case, or initially paid, wouldn't have even satisfied that. But there was an effort to try to get in touch with Mr. Webster's family in order to take care of those issues. Again, I just want to make sure that I put that out. So that
Until
there's-
March, was there any effort on your part to tell this court that either he didn't have the money or he should be declared indigent or anything until 2 months after we had dismissed the appeal?
No, sir. That is correct.
And at that point, you did not ask for the appeal to be reinstated or for him to be declared indigent. You simply asked to withdraw. Is that correct?
I don't believe that's correct, sir. In the motion to withdraw, I believe that there is reference to him being indigent and asked that he be appointed counsel.
Your motion's titled Motion to Withdraw from Representation as Counsel of Record, correct?
Yes, sir.
In count one, you say there are irreconcilable differences, namely because he's indigent and cannot pay you, correct?
Yes, sir.
You do say that counsel should be appointed to assist with his appeal.
Yes, sir.
Do you ask that he be declared indigent or that his appeal be reinstated?
No, sir, but again, and again, with all due respect to you, sir, I think your question was trying to give the impression that somehow, some way, I did not ask for his appeal to be reinstated for him to get counsel, and I think a fair reading of that, no one would agree with that assertion.
Okay. Do you know of any grounds why an appeal should be reinstated 2 months after it's been dismissed after 2 orders to show cause?
Are there grounds when an appeal could be reinstated? I believe Mr. Webster's appeal was reinstated, sir, for that very reason.
Okay. Through somebody else's efforts?
Yes, sir.
Right. Jason Herrick versus State, case 15-3831. You were counsel of record there.
I was, sir.
April 27, 2016 order directed to appellant, which means to you, correct?
Yes, sir.
Why the case should not be dismissed for failure to file an initial brief, correct?
Yes, sir.
Following that, in fact, the next day, you advised and filed a notice of voluntary dismissal of the appeal. Is that correct?
That's correct, sir.
Did you provide a copy of that to your client? Or advise your client that you were taking a voluntary dismissal?
Absolutely. Absolutely. And if I might, sir, because I think this is important to state for the record, Mr. Herrick initially wanted to appeal. My advice to Mr. Herrick was to not appeal, specifically because of the result in that case. Mr. Herrick did not go with that advice initially, and then eventually, upon further discussion, decided that he did in fact want to withdraw the appeal. That appeal was withdrawn, and the petition for voluntary dismissal was done with Mr. Herrick's knowledge, advice, and consent.
Right. It certainly appears that there's been an ongoing pattern or practice of you not responding to this court's orders. Would you agree with that?
Yes, sir.
And there certainly has been a practice and a pattern of you not filing record on appeal in a timely fashion, and very frequently not filing your initial brief on time, to the point that you've been ordered repeatedly to show cause why the case shouldn't be dismissed for your failure to file the initial brief. Is that correct?
Yes, sir.
I'm not sure if either one of y'all has any more questions. No. All right. Mr. Smith, we will send out an order advising you of what decision we make and what steps we intend to take.
Yes, sir.
All right. Okay. We will be at ease then. Thank you.
Sir.
We're in recess.